All right, I think we can get started. Welcome. My name is Diana Dominguez, and on behalf of the Presser Law Firm, we would like to thank you for joining us. As we enter 2022, continuing to navigate the COVID-19 pandemic and all the changes this wonderful new year brings, now it's the perfect time for individuals and businesses to consider their estate planning and asset protection goals. So the overview of today's presentation, today we will cover what is asset protection, why asset protection matters, effective asset protection strategies, and New Year resolutions for your asset protection plan. How will this presentation help you? If you started 2022 with a New Year resolution, this presentation is for you. Each new year brings an exciting opportunity and for fresh starts and new beginnings. Whether you're thinking of getting married, having a child, starting a new business, buying property, moving to a new state, investing, any kind of changes that you want to make changes your financial situation. And that requires you to have a well-constructed and most importantly, updated asset protection and estate plan. If you are one of the many who is starting this year with exposed vulnerable wealth, this presentation will educate you on how to obtain financial self-defense and security. Or if you're part of a client family, this presentation will help you determine if it is time for you to make changes or to update your current asset protection and estate plan. So let's go back to the basics. And talk about what is asset protection. Simply put, asset protection is the adoption of a range of legal strategies to shield your assets against lawsuits and creditors. The goal of asset protection is for one to own nothing that is eligible for creditor seizure by transforming unprotected assets into protective entities. So please take a look to the few listed assets that I've put on the screen. If you happen to own any of these under your personal name or under your living revocable trust, your assets are exposed to lawsuits and creditors, which means that you can lose them. And exactly that is why asset protection matters, because what you don't own can't be taken away from you. Since the start of the COVID pandemic, most Americans to various extents have faced health and financial hardships. If at any point in this financially unstable time, you experience bankruptcy, divorce, tax claims, property foreclosure, creditor seizures, governmental seizures, or any type of legal claim that you can imagine, not only can it be emotionally and economically devastating, but it can also mean one's biggest financial catastrophes. The good news that we should take in this year is that although you may not always be able to foresee trouble, you can certainly plan for financial threats before they appear. And the best way to plan for financial threats before they appear is by implementing effective protection strategies to your asset protection plan. Essentially, the goal is to use available legal strategies to reorganize your wealth so that it is protected by law from creditors and lawsuits. Here at the Presser Law Firm, we don't think that there's one specific strategy that we use for asset protection. That is because each available strategy serves a very specific purpose. Sometimes we recommend our clients to combine asset protection strategies for greater protection, but it really varies case by case. The use of protective entities is one example. You might be familiar with some of these entities. A few popular, just to name a few, are limited liability companies, limited partnerships, and corporations. Under the law, these protected entities and entity owners are viewed as separate legal beings. And this distinction is very important because the moment that you move an asset away from your personal name and under the right protective entity, you limit any personal liability that is tied to that asset. What's key here is to remember, and always keep this in mind, power does not lie on whether you own an asset. It lies on how you control and how you can benefit from an asset. And that is exactly what protective entities offer. We have another example, which is exempt assets. Unlike exposed assets that we discussed earlier, there are some assets that are protected through state law from creditors, or as the name suggests, they are exempt. Commonly exempt assets under federal law, and in most states are your homestead, your college saving plans, wage accounts, pensions, retirement accounts, profit sharing plans, and life insurance contracts. And as great as these exceptions sound, they always come with caveats that a proper asset protection attorney can help you navigate through. For example, in some bankruptcy cases, you may or you may not be able to utilize these exemptions. Or if you decide to move to a different state, exception rules change. And depending, of course, on your specific situation, sometimes creditors such as the IRS or other governmental agencies can choose to ignore the exception laws completely. We have this great resource in our page, assetprotectionattorneys.com. We have listed all the exception rules that fall for every state. So certainly take a look at those so you can see, maybe you have assets that are already protected. Another great asset protection strategy that we like to use is the use of co-ownership arrangements. Co-ownership planning, it's the concurrent property ownership by two or more people. Common types of co-ownership planning that you might have heard of in the past, tenancy in common, joint tenants with rights of survivorship, community property. But for asset protection purposes, I want to focus on one specific one, and that is tenancy by the entirety. Tenancy by the entirety holds a very high protective value. Under tenancy by the entirety, married couples can hold equal ownership interest in an asset. This asset oftentimes tends to be real estate, and under this arrangement, each spouse owns 100% of the assets. To be clear, that does not mean that a spouse owns 50% and the other owns 50%. It means that as the units, they both own 100%. And this is very important to understand because of this, creditors cannot go after the asset if one spouse is sued because the other one holds an equal interest. The other one controls and has ownership of the property as well. So this wonderful asset protection is offered to spouses under tenancy by the entirety, but it also comes with estate planning benefits. Spouses that own assets under tenancy by the entirety have rights of survivorship benefits. This simply means that if one spouse passes away, the other spouse becomes the sole owner of the home. And this is really great because it avoids all the headaches associated with probates. Probate can be a very extensive process, a very costly process, time consuming. So this is not only financially feasible for a lot of people who are looking for a protection strategy, but it's available certainly for couples in Florida. That said, tenancy by the entirety is not available in all states. In the states where it is available, it may not be available for all types of assets. Most importantly, and this is key to understand, is that if both spouses share a debt, the asset protection portion of tenancy by the entirety is void. And as a result, this form of property ownership arrangement should not be relied on as the only creditor defense, and should be consulted with an asset protection planner for ways to add extra layers of protection in case the couple does end up sharing the debt, in case of divorce, or in case you move to a different state. The last strategy that I'd like to mention for the sake of time is the integration of one's state plan with your asset protection strategies. Just to give an overview, a good asset protection plan goes hand in hand with a good estate plan. Unfortunately, a 2021 Gallup poll found that only 54% of Americans remain without a proper plan in place on how their money and estate is to be handled after their death. And this is very alarming because without an estate plan, your unprotected assets will likely pass to unintended people, get distributed in the wrong ways, or they might potentially lose value over time. With a good estate plan, however, you can guarantee that you're passing down your assets without probate. As I mentioned, it's very costly and very time consuming. You can save money on taxes if you plan it accordingly, and you can protect your beneficiaries of your estate from potential creditors. The same asset protection that you have in your plan can pass down to your heirs, which is the wonderful thing about implementing and integrating these two plans together. Additionally, and this is really great too, if you were, God forbid, to become incapacitated during your lifetime, an estate plan can ensure that a trusted individual handles your healthcare decisions and assets. You have to ask yourself, all these questions. If something were to happen to you in your lifetime, an estate plan doesn't only work for when you die, it works for when you're alive. And this one tool is often very beneficial when we incorporate it. Oftentimes here at the firm, we like to use trusts and incorporate trusts to our clients' asset protection plans. A trust is a vehicle in which you can place some or all of your assets to be managed by one or more trustees for the benefit of its beneficiaries if something were to happen to you. You get into a car accident, God forbid, you develop a medical disability and you're not able to make decisions for yourself, you should have a plan already in place before these things happen. And, there are a variety of different trusts that can be placed to provide you with the most asset protection and estate planning benefits, of course, depending on your goals and your specific circumstances. So as we enter 2022, let's talk about some New Year resolutions for your asset protection plan. First, I would say it's a great way to start the year with a financial checkup. You can do this in the comfort of your home. You can do this with your asset protection attorney. Essentially, what you want to do is you want to list your assets and their value. No matter how big or how small you think an asset is, you should know which assets you can lose. And of course, which assets are already protected by law. If you live in Florida, for example, retirement accounts are exempted. Your homestead is exempted. Your life insurance is exempted. Knowing these things help you develop a plan so that you can then target your liabilities. Which assets you currently hold under your name that could potentially go to the wrong hands. That's why we should anticipate trouble. You should list all of your liabilities. Ask yourself, do you owe money? If so, who are your creditors? What are their names? How much do you owe? All these questions are very important because if you can anticipate things before they happen, you can plan for them. And anticipating for the worst case scenario is very important. You know, it could be a lawsuit, it can be divorce, incapacitation, death. The important thing is to always, always, always be proactive and never reactive. Lastly, I think a good takeaway would be to coordinate your asset protection plan and state plan with an attorney to develop the best plan for you. If you already have one, remember that you should review your plan every 3 years. If you're planning or experiencing any life changes, you know, like we were mentioning, marriage, having a child, if your child is having a child and you have them in an entity, if you have them in your trust, you have to make sure that your documents reflect all of those changes, because keeping your estate and your asset protection up to date is the best way that you can ensure that the plan that you have works for you. And with that, I welcome you, if you have any questions about today's webinar, to please submit them via email or the chat box. You can always subscribe to our weekly newsletters, get updates for future webinars, blogs, and presentations that could be hosted near you. All the strategies that we discussed today, we've written extensive blogs, and there's even webinars that have been dedicated to them on their own. So I would definitely recommend you that you check them out. And of course, I welcome you to schedule a complimentary consultation, preliminary consultation with one of our asset protection and estate planning attorneys to get started with your plan for 2022. And of course, review your current plan to make sure that it's all good to go for this year. You can follow us, of course, in our social media. We post weekly vlogs, and every month we have a specific webinar on either estate planning or asset protection. Thank you once again for joining us. I hope you have a wonderful day, and we wish you a very healthy and wonderful new year. Thank you.